so let's get started. First, I want to remind you to turn off your cell phones. Thank you. It's my pleasure to introduce Karen Ashworth, a Texas estate planning attorney, who also happens to be the daughter of Ken Ashworth. Karen grew up in Austin, earned a degree in economics and sociology from Rice, and then went on to get an MA in sociology and a PhD in law at the University of Alabama. She has 2 grown children and enjoys the piano and gardening. Now, as you've been warned, there are 2 things in life you can't avoid. One of those occurs today, the April the 15th tax deadline. But what about the other inevitability? Have you got all your ducks in a row? Does your family know your wishes? Have you completed all those important papers? And what if you become disabled or unable to make financial and medical decisions for yourself? Karen is here to guide us through what we need to know and give us peace of mind, whatever what life has in store for us. Please welcome Karen.
Hello, I'm mic'd up, so hopefully you can hear me. Yes, I am Ken Ashworth's daughter, so I know, I hope I'm at least 1/10 as charming and brilliant and interesting as my father. My talk tonight is not going to be nearly as interesting as, say, a play written about living in a senior community. So for those of you who are new to the community and don't know, my dad wrote a funny, I call it a dark comedy, about living here, or living in a senior community. And so I may make slight references to the play here and there, but I'll set the stage in a moment. But I'm an estate planning and probate lawyer here in Austin. And my talk tonight is the field of estate planning and probate. I've always said it's 100 miles wide and 100 miles deep. So, I mean, I could talk for an hour just on one little piece of that. So I'm going to try to give you an overview. We're going to cover, it's going to be like an iceberg. We're just going to cover a little bit of the tips of a lot of these concepts. And so I think the good part of this, hopefully a lot of y'all will think, I know what she's talking about. I've done that. I have that. I'm set. I've done the right things. You're going to feel good about what you've done. And then there may be a couple things you go, oh, I need to revisit that, or I need to think about that. And then if you do need to do a deep dive, then that's when you go to your circle, your inner circle of advisors, your financial advisor, estate planning attorney, CPA, that kind of thing. So again, I'm just here to give you an overview, and hopefully you'll have some interesting takeaways. So when Dad wrote the play, I'm going to set the stage for you. There were 5 chairs on the stage around the coffee table. And there were 3, so for 5 friends who gather on Monday evenings, I believe they essentially gather to solve the problems of the world. And there are 3 friends gathered at the start of the play. And they are talking and they are concerned because one of their friends, there's the mic, is missing. So Harry's missing, they don't know where he is, they've sent one of their other friends off to find him. And this is just kind of a reminder that we've got to assemble a village of people to take care of us. And what do? Harry is missing. Well, we hope that he has planned for his disability, and hopefully he has some of his planning. And the first thing we're going to do is figure out if he's got a medical power of attorney. Most of y'all probably in this room have one, and that's the document where you designate an agent to make medical decisions for you, only in the event you can't make them for yourself. This document only springs into effect by law in the event you are actually unable to communicate your own wishes about your own medical health care. But then it enables you to appoint someone to make those decisions for you, and it's going to be things like, do I need a second opinion? Are we going to consent to surgery? Do we like this new medication? And where am I going to live? For folks who don't already live in Westminster, their medical power of attorney may be helping them find a place to live, and hopefully they end up in a great place like Westminster. So the medical power of attorney, way to think about that, they're essentially the guardian of your person. They take care of your body, your day-to-day living, and of course your medical decisions. There's a handout, if you've got one coming in, and it's got a brief description of each of these documents as well, to kind of help you as you go through it. You can also appoint co-agents, but the doctors, I'll tell you from a practical standpoint, they're not going to call both your agents and make sure they make the same, they can agree or going to make the same decision. So if you do appoint co-agents, sometimes you got 2 kids and you don't want to prefer one or the other, or just whoever's available, make sure you got language in there that they can act independently. Because the doctor's just going to call the first one, can't get them, they call the other one, so you want them to be able to act independently. And same thing, next document we're going to hope that Harry prepared is a financial power of attorney. Because then, if he's missing for a while, we're worried about, well, who's going to pay the bills? Who's going to file his income tax return against David? So the financial power of attorney is a document that limits the agent, to take care of your financial matters. So I had a young person at my office prepare this for me. So there's a lot of fun stuff. Okay. And the thing about the financial power of attorney, the medical power of attorney only takes place when you're incapacitated. On the financial, you have an option. You can say, I trust this agent, I'm going to be traveling, I've managed my investment portfolio my whole life, I'm done. I want my agent to step in right now and help me with my financial matters. Or you can say, nope, I want to do it all myself, I'm only going to have this agent come into play, and in fact, I'm actually incapacitated, which requires a doctor's written evaluation to say you're incapacitated has to be attached to the durable power of attorney, which is often recorded in public record because financial institutions want to see it recorded. So a lot of folks say, getting declared incapacitated is a big hassle for my family. I don't want to have to go through that. I trust my agents. I'm going to go ahead and have it spring into effect right now. They're going to help with things like buy or sell your car, real estate if you have any, maybe perhaps manage a large art collection, maybe help manage all those green boxes you've been accumulating in your room. Personal property items linked to that. And then you can grant your agent specific powers, but they have to be specifically granted in that document, and that is things like making gifts on your behalf. And it's typically continuing a pattern of gifts that you may have made during your lifetime. Gifts to charity, birthday presents to the grandkids, holiday gifts, that kind of thing. And then your agents also, you want to grant them special powers to perhaps set up a trust to manage assets on your behalf. And it's rare, but there's something new called hot power. And it's hot because it's like a hot potato and you might not want it. You have to really trust your agents, but you can actually give them the authority to change your beneficiary designations. I know, this is so rare. The other rare power is to enable them to appoint a successor agent for you. So if they can't serve, they can appoint somebody. And again, you may not know who that person is. You may be incapacitated. So I don't think I've actually used these new hot powers. Just so you know they exist. But then another medical document you're going to want in your collection there is a living will. In Texas, it's called Directive to Physicians and Family or Surrogates. And this is you, while you have capacity, telling your family, telling your doctors what you would want in an end-of-life situation. And I want you to be sure you talk to your family about what you would want. And there's often, I do a supplement.
Advanced directive and what have you.
Yeah, it's often called an advanced directive in other states. So this is what we call it in Texas. And again, this tells your family and your doctors what you would want to happen if you're in an end-of-life situation. And the form actually distinguishes between 2 situations. One is, they call it a terminal condition, obviously end-stage cancer or something like that. The other is an irreversible condition, like a coma. Like death isn't imminent, but if they do life-sustaining treatment, they put you on a feeding tube and they intubate you, you're on a breathing machine. I mean, they can keep you going for a long, long time. So they kind of distinguish between those 2 situations. Some people want to treat them differently. But again, you get to say, keep me comfortable, but I don't want any extraordinary life-saving measures. And then the other option is, of course, all treatments available, keep my body going as long as possible, even though you're obviously incapacitated if this form is taking effect. People often call this form a do not resuscitate. They'll come to me and they'll say, I need a DNR. I'll say, okay, great. I think you're talking about a directive, which is a living will. A DNR is actually a medical document that has to be signed by your doctor. And it's my understanding, and maybe some of y'all in the audience can educate me on this, that you get a new one every time you go to the hospital. And each time you're in, they assess you and say, okay, do you want to be resuscitated? Yes, no, and the doctor has to sign that I do not want to be resuscitated. So if you go into cardiac arrest, they're not going to do CPR, that kind of thing. Now, I've had clients, and if you're in a terminal condition, I had a client with ALS. He had an out-of-hospital DNR. He had it laminated and plastered on his refrigerator, so when EMS came, they would not administer CPR. Medical terms. But, so that's what, a DNR is different. So you've got the two different types. You've got a regular DNR, and then you've got an out-of-hospital DNR. But typically, that's only going to be special case, terminal, that kind of thing. But again, talk to your doctor, not your lawyer about that. Okay. Now, HIPAA authorization, the Health Information Privacy Act, every time you go to the doctor, they have you sign their own HIPAA authorization because now health information is private. And they can't talk, I mean, I remember when my daughter turned 18, I couldn't even make a doctor appointment for her anymore. They'd say, I'm sorry, we can't even acknowledge that she's our patient. So this form, if the doctor doesn't already have one, say it's an emergency situation, you're being admitted to a hospital that doesn't know you, you've got a general HIPAA authorization, and it just lists your family members, usually the agents from your medical and financial power of attorney are going to be on there, and these are the people that the doctors can talk to about. Now, these people can't make decisions, but they can at least know what room number you're in, what's the prognosis, what's happening, another form I do in conjunction with all these is the declaration of guardian. This is for a court-appointed guardian. This is you telling the court, if I need a guardian of the person, we name the same people that are in your medical power of attorney. If I need a guardian of my estate, which is managing my assets, then we use the same people that are designated in your statutory durable power of attorney, or financial power of attorney. So we do this kind of belts and suspenders. You may not ever need this, but if you did, it's nice to have just so the court knows who you would want appointed. More often I do this if there's somebody you don't want to serve. Oh, my sister's gonna come out of the woodwork and want to be my guardian and take over all my stuff and put me in a home and all that. So spare the drama. You can say, no, this person's not entitled to serve. So if that person were to file a guardianship to try to push the kids out or push the designated agents out of the picture, that this document protects in that situation. So, and then the last document I do, well, actually the second one, there is, you can designate an agent to take care of the disposition of your remains when you pass away. And again, typically this is the same person that you designated in your medical power of attorney. And there is a special instructions page where you can say, I would like to be cremated and have my ashes sprinkled in the ocean off the coast of Santa Barbara, whatever it might be. And this is particularly helpful if you've got a large family and you want to be cremated. Because if you don't have it, the fact that you want to be cremated in writing, signed by you, then all your next of kin have to sign off on the forms for the crematory. So this is real helpful just to make things easier, because it's a difficult time. You've just passed away, people are grieving, people are all over, they're trying to get organized, and they're trying to figure out, well, who can go to the funeral home and crematorium and take care of all of that. So nice form to have. And I had one guy who wanted everybody wearing a wine shirt, drink margaritas, and celebrate his life. So you can put that on your instruction page. And some folks want to do an anatomical gift statement. They want to, and you can also do this on your driver's license. You can go to donatelifetexas.org. That's the same link you get on your driver's license, and you can go sign up to be an organ donor. And then there's actually a separate form as well, and you can specifically donate eyes, organs, skin, tissues, that kind of thing. If folks want to donate their entire body for medical research, that is another separate form that you actually have to get from the medical school. And I've got a whole list of all the medical schools here in Texas. So if you're interested in full body donation, you contact them, and then they have a separate form that you fill out with them. So then on your instruction sheet, you say, I'm donating my body to UT Southwestern Medical School, so that they will know not to send your body to the crematorium, they'll know to contact the medical school and have your body donated. And typically then they provide the family with the cremated ashes. But that is the disability and taking care of your body documents that we hope Harry has in place. The other element of estate planning, so is predominantly planning for your disability, and then next planning for your legacy, which is a nice way of planning for your death. A great quote. The man who raised me is a big fan of quotes, so I have to quote him tonight. I got to think of it. What you do is your history, but what you set in motion is your legacy. So think about that. My dad said a lot of things in motion. Mainly my education that got me to law school. Okay. So when you're planning your legacy, here we are in the storyline. So now friend number 4 bursts onto the stage. We found Harry's body. He's in the back seat of my unlocked car. And they figure out, well, we did go for chili burgers. And you left the car unlocked, so that's where they find Harry's body. So now we hope Harry has one for his legacy. And we, first thing, who do we call? Well, we can call the agent under the medical power of attorney, the agent on his disposition of remains, his next of kin, financial advisor, CPA, his estate planning attorney, if we know who that is, the named executor, trustee, pastor, or Betsy. Betsy has all the answers. So we hope that Harry has compiled some important information. If he does not have a will, the state of Texas has one for you. There is a great chart at the Travis County Probate Court. The intestate succession laws in Texas are so complicated. It's like 3 pages long. There's colored pie charts explaining, well, if you're married and have separate personal property, it goes here. If you have separate real estate, it goes here. What if you have community property and you have children of the marriage, it goes to the wife. But if you have children from a prior marriage, then you get, and it is super complicated. So if you don't have a will, then your family gets to go to the court and they're going to look at that intestate succession and figure out who your heirs are. And there still has to be a court proceeding. They do a determination of heirs. They appoint an attorney ad litem at the court, at the probate court, to investigate your heirs. And the person who applies for this determination then has to provide witnesses and extra fees involved. It's kind of a big deal. So there is a process if you don't have a will, but it does make it easier on your family. And obviously you get to say what you want if you've got a will or a living trust. And I'll get into some more details on that in a minute. So important things, just ahead of kind of getting into the digging in on your legacy planning. If you've got an original will, you want to keep it in a safe place, and you want to let your agents under power of attorney, your executor, let them know where you keep it. Because the original will is needed to probate. We don't need the original financial power of attorney, medical power of attorney. Copies of those are legally viable. But for that will, it's preferable to have the original. Now, if oftentimes, not often, but every now and then you can't find the original and you have to probate a copy, which is doable, but you have to notify all the heirs. So if there's somebody in that will that you're cutting out, or that you've neglected to mention, or there's some disposition somebody might not be happy with, everybody gets notice, and that gives them an easier opportunity to contest the will because it's a copy and you have to prove it wasn't revoked, it's missing because after diligent search we just couldn't find it, and he talked about this will, and we're pretty sure that this is what he wanted to be done. So hopefully we can find the original. And then the other important information, and this just makes it easier for your executors and your family, is to have lists of all your family members with their address, phone numbers, email addresses. Make sure you've got lists of your assets, and it's really handy to have just even a current statement so they know how the account is titled, what your account number is, what the approximate assets are in those accounts. And sometimes you have people that are consolidated and they have 3 accounts, and you have people who have 25. It's just, the more complicated your estate, the more obviously you want to make sure you've got all your financial institutions, your contact persons, including your CPA, your financial advisor, your estate planning attorney, maybe you've got an insurance agent, those kinds of things. It's really nice to have all that information compiled for your family members. And have it, I think Dad used to call it the dead file. It's no dead. And I think it used to be red, and I thought to myself, red for dead. Okay, great. I know that for my dad's. And we got a lot of different scenarios when people come to the office and say, do I really need estate planning? Or do I need complicated, customized estate planning? Now, obviously, if you've got multiple marriages, you've got separate property versus community property, which can be very complicated in the state of Texas. A lot of people don't realize that the income earned from your separate property is community property. So any income assets that you accumulate during your marriage is community, even though the corpus, the asset, maybe it's a piece of real estate or a stock portfolio, that asset and the appreciation is separate, but any income it generates, whether it's stock dividends, rental income, wages, those kinds of things are going to be community property. So if you've got multiple marriages, and oftentimes you have kids from prior marriages, his, hers, ours, you're going to probably want to have some of those details outlined. A lot of clients have, maybe their children and their grandchildren are great, but they've got a niece who was disabled at birth or because of a car accident or something like that, and there's a chance she might inherit. You want to make sure your will has got some sort of special needs trust default provisions, because if they need to qualify for government benefits, you don't want those disabled beneficiaries to inherit assets outright. Because when they own assets, if they're on government benefits that look at their resources, they get bumped off. They've lost their Medicaid, they've lost their SSI, because they inherited money from Aunt June. So, so if you've got disabled family members, and I've got folks, we actually set up a separate standalone special needs trust to receive assets from multiple sources. And again, it enables that beneficiary to stay on their government benefits, which are there to provide for their some of their living expenses, but then the trust is obviously extra assets to enable them to have an enhanced quality of life, provide for vacations and all the electronics and fun stuff they might want in their household. Then we've got other folks who who have children who are just not successfully launching, or nieces and nephews, extended family members that are just not able to handle money responsibly, or there might even be some substance abuse concerns in the past or the present kind of thing. If you are the beneficiary of an existing trust, your mom and dad, your grandparents passed away, set up this trust, it's really great, it's helped you supplement your standard of living throughout your life, and now you're going to pass away, you've got to go back and look at that document. You might have what's called a power of appointment, where you can reach into that trust that grandma and grandpa created and appoint it under your own will to your family or to whomever that document allows. Usually it'll say to any person. Sometimes it says to the bloodline of the grantor, the person who created it. So it's like, okay, I can appoint it to and among my kids, my nieces and nephews, because they're all descendants of my grandparents, that kind of thing. So if you've got a trust from another source, you always want to look at the document, see what happens when you pass away. Does it go to your kids? Does it go to other family members? Do you have that power of appointment to direct how you want the remaining assets to go? A lot of folks, not a lot, some come in and they want creditor protection. They were a lawyer. I actually had this happen. He was a lawyer, he drafted some deeds, there were some mineral interests, and I did it wrong, and so. Or they were a landlord, they were a doctor. Some folks just have a profession and they're worried about creditor protection, asset protection. So they definitely need some in-depth estate planning. Some folks have, especially here in Austin, they bought real estate in the 70s and it's just gone through the roof. It's a great property, it's generated some rental income for a while, but now they're like, you know what? I just want to continue to get the income stream, but then I want it to go to charity because there's going to be these huge, huge capital gains. Well, guess what? You can put it in a charitable trust, get an annuity income for life, and then when you pass away, it goes to the charity, and they don't pay any capital gains tax on the growth, and it's just a win-win. So there's all kinds of really creative stuff you can do if you have charitable intent. Again, art collections, car collections, assets that are highly appreciated, all kinds of neat stuff there. If you have out-of-state assets, a lot of folks have a vacation home in New Mexico, Colorado, California, and you definitely don't want to have to do what they call ancillary probate. Probate your will here in Texas, but then oops, we've got this asset. Well, now we've got to take your will from Texas, get a certified copy, and go probate it there too. So you've got this ancillary probate, which is easily avoided. You can put that out-of-state asset in a Texas trust, in a Texas limited liability company. There's ways to own it so that it becomes essentially you're converting the real estate to a personal property asset here in Texas. So and then you can do assignments on that. There's all kinds of neat ways to avoid probate if you've got out-of-state assets. A lot of folks here have moved here from out of state. They moved to Austin because it's so cool and they want to be near their kids or their grandkids. And people say, well, I've got to go see a estate planning attorney right away because my documents aren't any good anymore. Well, if they were valid where they were prepared, then they're valid in Texas. Now, I will tell you they're foreign. You got the foreign wills, you got a probate in Texas, but they're still valid. We just have to show the court the extra steps that they were valid in the other state. And Texas is nice because it is a very simple probate state. It's not like California, everybody has a living trust. New York, Florida, because probate there is very judicially monitored. You've got to ask the court for permission to do every little thing, to sell a piece of real estate, to make disbursements, to pay the taxes, all that kind of stuff. So Texas is very, we call it independent administration. So we're looking for some language in that foreign will that says, my executor has the authority to administer my estate with as little court oversight as possible. That's kind of the magic language we're looking for in those foreign wills. So if that's in there, a lot of us say, no rush, but if there's other things you want to change, let's go ahead and get you a Texas will. And of course, if you've got complex assets, you've got business interests, you've got closely held stock in your child's company that they started, or SpaceX, or whatever, you're going to want to possibly do some creative estate planning. And not everyone is aware, we've got this estate tax. And that's, when I graduated law school, I think the estate tax exemption was $500,000. So if you had a house and a retirement plan, you had a taxable estate. So everybody had to, and you had to set up these trusts to capture the estate tax exemption, so then that asset would be included in your spouse's estate, and everybody had all these very complicated, we call them AV trusts, all these wills with trusts. So the estate tax exemption has gone up and up and up over my career, and we're currently at 15 million. So last July 4th, we got the new tax law, and the exemption, it was 5 million doubled, so 10 in 2016, but that was due to sunset because we had the Budget Reconciliation Act, and it was going to sunset January 1 of 2026. So July 4th, 2025, they changed it to 15 million, and they used a little, I'm not going to call it trickery, but they just did some things. They made it so you don't have to look at budget reconciliation based on what the law would have been when it sunset. We look at budget reconciliation from where we are now, and they were able to make it a permanent. So there is no sunset to that $15 million exemption. So if your assets are 15 for an individual, 30 million for a married couple, you don't have to worry about estate tax. And we've got this concept called portability, so you don't have to set up a trust to capture it. You've got, portability is complicated, but just know it's not quite as urgent to do the tax planning as it used to be. But there's also a generation skipping transfer tax. And a lot of folks don't realize that my kids are doing great. I'm going to give money directly to my grandchildren. When money goes from you to a skip person, a grandchild, or a more remote descendant, there is an additional flat 40% tax. Yeah, in addition to the estate tax. But the good news is the exemption is also $15 million. For a long time, it was only $1 million. Well, the estate, so it used to have separate, every trust that you were always looking for that GST exemption. So if your estate is exempt, it's also going to be GST exempt. So that's the good news. That it's a nice big number. I just want you to be aware. You'll see GST or generations of transfer types sometimes in your boilerplate language in a lot of documents. Talked a little bit about this already. Do I need to avoid probate? And the short answer is no. We have independent administration here. It's not a super complicated process. The only thing, the steps involved in probate here is you have to have your will validated. So you have to take the original will, present it to the court. It's an original, it's valid, it's witnessed, it's notarized, and then the executor is qualified. They're not a felon, they're not from out of state, you don't have a local agent. So as long as your executor is qualified, then they are independent. The court has you trust this person and they do too, and they're like, you're independent executor, here's your letters testimony, go identify the assets, gather the assets, prepare an inventory. But now the court doesn't even require you to file an inventory with the court. You can file, if you don't have any debts that are still owed and unpaid, you can file an affidavit in lieu of inventory, so the assets of your estate remain private. So you just file that affidavit in lieu that says, I prepared an inventory, and I gave a copy to everybody in my named in the will, all the beneficiaries, and then the court has very little oversight, which is nice. But there are reasons to avoid probate. Some people want privacy. They don't want their will, even though their inventory won't be listed. They don't want their family and how their assets are going to pass a public record. The will was filed in public record. They may want consolidated asset management during their lifetimes, and then the ease of transition to their beneficiaries without having to go get the executor appointed. They just got a trustee designated in their trust, their revocable living trust, which becomes irrevocable at death, and then that's already in place. But there's other ways to avoid probate. So you can have assets pass outside your will, outside your trust, just directly by, they might be joint tenant with right of survivorship. That's kind of the default when you go to the bank. You open a bank account with your significant other, you're going to put a joint name with right of survivorship. And all that means, all you need is a death certificate. You take that to the bank, the joint owner is automatically 100% owner of that account. And it doesn't go under the will. And I've seen wills where they're like, I want my Raymond James account to go to my niece, and then the niece goes, the probate, the executor goes to get the asset. Well, it had a payable on death or a living right of survivorship or the joint owner, and it's gone. It didn't pass under the will to the niece. So you got to coordinate these titlings with your will and other documents. But you can avoid probate, especially with husband and wife. Sometimes it's really nice to just have everything passed to the survivor, joint tenants with right of survivorship. These pay on death, payable on death, POD. That's what we call them in Texas. You're going to call transfer on death, TOD. You can now do this on any financial account, whether it's a bank account, stock brokerage account, CDs. You can even do it on your car title now. That's very new. There's a form where you can put a POD on your car. So all these assets pass with nothing but a death certificate. I also do transfer on death deed on real estate sometimes. That way the house can go to named individuals on that transfer on death deed. Again, bypasses probate. And then, of course, the biggies that we're all familiar with, been going on for decades, is the beneficiary designation on your retirement accounts and on life insurance. And of course, you can designate trusts for people, or you can obviously designate individuals to receive your retirement accounts and your life insurance, which I'm going to talk about a little bit more in depth. So a lot of times you go to a cocktail party or you meet someone new and they say, do you have a living trust? You gotta have a living trust. I have a living trust. Do you have a living trust? Oh my God, I don't have a living trust. oh, I gotta run to my attorney. Oh, I need a living trust. I say, well, is your friend from California or New York or Florida? Well, they all have living trusts because they're trying to bypass probate. And then you talk about the reasons why you might want a revocable living trust. Again, privacy, it doesn't go through probate, and it's harder to contest a trust that doesn't go through probate. They actually have to find something wrong with it and file a separate lawsuit. If you have family members, you're worried that are going to come question the disposition of your estate. Privacy, harder to contest. There's some reasons you might want a living trust. Sorry, I'm going to hit myself here. But, and again, of course, the asset management while you're alive. And then you've got your trustees in place, so it just transitions without having to have the executor appointed. So when you're setting up your will and your trust, there's some things to think about. Where am I? Okay, so, inside your will, you're going to think about your personal property and people that you want to recognize, but maybe not leave a big chunk of your estate. Maybe you want to make sure your jewelry goes. I've got 2 daughters, so I can just say my jewelry to my daughters as they may agree. Or I may say, well, you know, Becca really likes that diamond necklace, and Ashley just wants the turquoise. So, you know, those kind of things. Cars, art collections, pets are a big one. I'd like to do a specific provision about your pets to designate people to actually receive your pets. That I want it to be child number 1, child number 2, friend down the hall, my veterinarian who loves my really difficult cat who bites everybody else. And then I often recommend, you know, well, this person is going to have to take care of this animal. Would you like to leave them a little bit of money to cover those vet expenses? So I'll have a little formula about, $1,000 for every year of the life expectancy of the animal. But sometimes that number is $5,000 or $10,000. So you just never know. It depends on the pets and the individual and how they feel with the pets. Sometimes, again, you want to just recognize a friend, your partner, your niece or nephew with a nice lump sum of cash. I put that in the special bequest section of your will or your trust. And while we're talking about cash gifts, I want to mention, we talked about this big estate tax exemption of $15 million. That also applies to lifetime gifts. But there's also an annual exclusion. So you got the exemption, but then the exclusion is just that annual number. Remember, it used to be 10, and it's been indexed for inflation. Well, now we're up to $19,000 per person. So each of you in the room could give $19,000 to any individual, $19,000 to each individual, and not have to tell the IRS about it. If you're a married couple, you can double that number. You give $38,000 because you're both giving $19,000 to that individual. If that individual is married, individually you can leave them $38,000 because you're giving it to them and their spouse. So that's I just wanted to make sure you're aware the lifetime annual exclusion amount is $19,000. This also applies to paying education expenses and medical expenses if you pay them for that other person directly to the education institution or the medical care provider. So those don't count towards your exemption. If you want to make larger gifts, then you file a gift tax return each year. When you file your personal income tax, you also file a gift tax return. It's Form 709, and you don't pay any tax because you've got this $15 million exemption. But maybe you want to put $100,000 into your grandchild's 529 plan, so you report the $100,000 gift, and they shave that off your $15 million. So when you die, you have $14,900,000 left to apply to your estate when you die, because you gave $100,000 away when you were alive. And that $100,000 goes into a 529 plan where it grows and grows and grows and grows, but you only have to report $90,000. So there's some nice ways to leverage gifts. Keep them in. Always got to have that conversation of, if you're married, how do you want to take care of each other? Obviously, we've got the $15 million exemption, but at the first step between a husband and wife, there's never any tax due. Because if your estate is larger than the exempt amount, we have an unlimited marital deduction. So you can leave your spouse, say your combined wealth is $50 million, so your share is 25. What did I just say? Did I say 50? Okay, so your half's 25. So yeah, you've got the $15 million exempt, and then $10 million of that qualifies for the unlimited marital deduction. The big question is, do we put the exempt amount in a trust? That way, it's 15 when it goes to my spouse, and then she lives another 10 years, it grows and grows and grows, and it's not included. So now that 15 is 17, 18, and it's not included in her estate at all. And then the 10 that you gave her plus her 25, well, that's the unlimited marital deduction. Those assets are included in a spouse's estate for tax at the second death, but they're not taxed first death. So that's the beauty of the marital tax, unlimited marital deduction. And some folks want to just leave it outright, and then that's really neat because you take the exemption amount and you file a state tax exemption form at Form 706, and if there's unused exemption, then it is affordable to the survivor, and I'll get down in the weeds on that. But just know that there's lots of things you can do to avoid taxes, obviously, the first step, and plan for estate tax and income tax planning down the road. And for other family members, you got to think about your children, your grandchildren. Do you want them to get their inheritance outright, or do you want to set up a trust? A lot of folks say, and when I was a baby lawyer, it was the trend to kind of pass assets to your kids, but then let them get it outright. They get a third at 25, a third at 30, and a third at 35. And then that number is like creeping up. It was 30, 35, 40. And then, and especially in Texas, because we're a community property state, I said, listen, why don't we let the child who's brilliant and successful, they can be their own trustee. They can still have access to the assets, manage the assets, be in charge of the investments, but it's in a trust, so it's not their personal asset, and it's separate property. So if they get married, they get divorced, they get sued. If they're in a career where they're likely to have a lawsuit against them, they're a real estate developer or something like that, then it provides asset protection as well. Some folks don't like their daughter or son-in-law, and they just want to make sure that the assets eventually go to the grandchildren. So there's all kinds of family situations to talk about. Then if you've got a family member who is not familiar with managing an investment portfolio, and you want them to have a little assistance, or maybe even a gatekeeper, put them on a budget, start teaching them about stocks and bonds and what distributions mean and how the income tax effects of all these things, then you might want a trustee. And then again, this is where I was going to talk about the generation skipping transfer tax as well. So when you set up the trust for your kids, that'll eventually pass to your grandkids, we want to make sure that GST exemption is noted on that trust. So for generation after generation after generation, it can pass on, and it's not subject to the estate tax, the generation skipping tax. So that would happen. I think we have the Rockefellers to thank for that, because the estate tax used to be like 55%, at one point it was even as high as 70%. They were skipping the kids and just giving gifts to the grandkids, and the IRS looked at that and said, hey, we're missing out on an opportunity to get tax. We're missing it for a whole generation. So they invented this generation skipping transfer tax to penalize skipping the kids. So if you're successful kids, now you've got this next generation skipping exemption now. So. A lot of wills, we include charitable bequests, whether it's a percentage of your estate, you might want to count it at a dollar amount, but a lot of folks have favorite charities that they have worked with over their lifetime or have been particularly meaningful to them at a certain point, and they want to include them. They can do, you obviously can do outright gifts during lifetime and get an income tax deduction. If the testamentary gift or the gift to charity is in your will or your trust, it takes effect at death, it's a testamentary gift, and then it's a tax deduction for your estate because it's a charitable donation. And then your IRAs. So your IRAs, we've got some special rules with IRAs now. Yes, here we are. So We have the new Secure Act, started in 2020, and there's been a Secure Act 2.0. So we've got some new rules in regards to your retirement accounts. You can still pass your retirement account to a spouse and have the life expectancy of your spouse used to calculate your required minimum distributions. And if you've got a beneficiary who is less than 10 years older than you, they can use their life expectancy, such as a sibling. If you don't have a spouse and you want to leave your IRA to a sibling. If your beneficiary is chronically ill or disabled, they get to use their life expectancy. They can roll it, they can take it as inheritance, roll it over, continue to use their life expectancy and take smaller RMDs. But for everybody else, children, grandchildren, non-disabled beneficiaries, they have the new 10-year rule, which means they have 10 years to withdraw every single penny from that IRA, from their share of what they inherit from that IRA. So they then are going to be in that quandary of, well, do I take a little bit each year? Do I leave it invested for the tax-deferred growth and then have a huge income tax hit in year 10? Obviously, they're going to sit down with their financial advisors and figure that out. But just so you're aware that this makes IRAs the ideal pot to make your charitable bequests from, because the charities don't pay income tax on it. So oftentimes, if you have charitable intent, I say, rather than putting your charitable bequests in your will, put them on your beneficiary designations. And there's two good things about that. One, the charities don't pay the income tax on it, and it's really easy to change them. You don't have to call your estate planning lawyer, do a codicil to your will or an amendment to your trust to change your charities. You can just do it by calling your financial advisor. Sometimes you just go online and change your charitable beneficiaries on your IRA designations. Unless, of course, you've done a Roth conversion, then you'll have the income tax rate. And the required beginning dates have changed. Most of you in this room are probably past the required beginning dates. For me, it's going to be 75. So that 70 and a half, that weird formula, not new 70, yeah, that's gone away. Some things are simpler. Oh, where's the tape? Okay. Again, I'm going to kind of skim the top. There's lots of things. Lots of other kinds of trusts. We talked a lot about that revocable living trust. That's a will substitute. Enables you to bypass probate and provide for the disposition of your assets. But there might be other kind of trusts you want to set up. You might want to make gifts, again, to the grandchildren. You want to set aside a trust and start putting some assets in there. You may want the trust to own a life insurance policy. If you own life insurance in your individual name, say you own a $1 million life insurance policy, when you pass away, that $1 million life insurance proceed is considered an asset of your estate. Unless it's owned in a trust, then the trust owns the policy, not you, and there is not included in your $15 million calculation of estate assets. Special needs beneficiaries might want a standalone trust, like I talked about that earlier. Again, the charitable giving, there's lots of really neat planning tools you can do with that to create a lifetime annuity for yourself, even for your children, but then at some point knowing that that asset is ultimately going to go to charity, and neither you nor your children are going to have to pay those capital gains taxes. So that's neat. That's a neat planning tool. So those are just some other ideas that you might want to consider with your estate planning attorney, depending on your situation. But in sum, you want to keep your original will in a safe place and make sure your people, your village of care, your financial advisor, or your family members, or your financial advisor know where you keep it. When I was a baby lawyer, we kept original wills for people in the office. And as time's gone on, now all the officers are going paperless, and they don't pay for the storage and liability and all. So a lot of times now the client, you're going to be responsible for your own will. And my advice too is don't put it in a safe deposit box. I have noticed a trend that the banks are getting rid of their safe deposit boxes. I've had a poor little 85-year-old not doing so well, and she's got to go down to the bank and empty her box and move it to another location, well, they called her again. Now she's got to move it again. So, but the problem with putting your will in there is that then you can't get access once you've passed away unless there's a co-owner. You might have your kids designated as an authorized signer, they have access, but once you pass away, that authorization ceases, and in order to get in the box, you have to get there's a statute, and a lot of banks don't, it gets more complicated. So it's probably better to put it in a safe place in your home. Some people get the little fireproof boxes that you can get, or just put it in a file folder and hope there's no fire. Want to talk to your agents, your financial and medical agents that we talked about earlier, executors and trustees, just so they know your wishes. A lot of times you're setting up a trust for your grandchildren, and you want them to, it just says very sterile legal language. This trust is for your health, education, maintenance, and support. Well, what does that mean? That means I want your education to be the most important thing. I want to fund you for K through 12, vocational school, grad school, PhD number 3, whatever you want. Just let you, I want this trust to be used primarily for educational purposes. And then I want it to supplement your living expenses. I don't want it to support you. I want you to go out and be your own productive citizen, but I'm going to authorize the trustee to make distributions to help you with a down payment on a house, or maybe some reasonable wedding expenses, or a family vacation every year, but certainly not to buy you a car that's not consistent with your standard of living, or waste the assets in other ways. And then you want to talk with your family about your planning. I have had people say, should I talk to my kids about this? And I found that a lot of times the successful planning is where everybody knows what's going to happen. And there's no surprises. And here's your judgment. Obviously, if you're in a situation where, that's not going to be a good situation, then you don't have to. But a lot of times that's just a general recommendation, is to tell your family what you've done. And you don't have to give them documents. You don't have to tell them details. But just generally, sometimes it's nice for them to know that you're taking care of things. Well, thank y'all. Y'all are my favorite audience because I can talk about death and disability, and it's okay. It's not scary. It's not blah. So thank y'all.
I think we've got time for a few questions. If anybody's got a question, please raise your hand.
Two questions. First, with a husband and wife married in Texas, a community property state, and one of them dies, does the remaining spouse get a stepped-up basis?
Yes, that is a beautiful question. I'm glad you asked that. That's the beauty of community property. It gets a 100% cost basis step up when the first spouse dies. So even though the
I can't hear. Was that a yes or a no?
Yes. When the deceased spouse, who only technically owns 50% of that community property, dies, 100% of the community property gets a step up in cost basis. All your capital gains are wiped out.
Okay. Second question, if you have one of the spouses is disabled and life expectancy is significantly less than 10 years, in fact, hospice, let's say, is involved, and they don't get involved in this, less than a year of life expectancy, but the financial institution holding that person's funds, and this is the reason that you need to have someone like you look at your documents, because my wife I have to hold a power of attorney for my wife, but Merrill Lynch will not honor it because they don't like the way it's written. It's not on their form, and consequently they're keeping the funds and churning the money so they get a commission, which is for the lawsuit. But my question is, what remedy does an individual like myself have with a big entity like Merrill Lynch that is not, in fact, allowing the funds to be used for my wife, who is totally disabled, has been for 2 years?
Yeah, that's a super complicated situation, and I would bring one of my litigation partners in. But I will tell you this, so the statutory durable power of attorney is a form in Texas. It is widely used, widely recognized. Unfortunately, I don't think financial institutions, you don't have to make them recognize it. And I've heard this story before. But yeah, you need to move those funds if you can, obviously. Yeah, you need somebody to talk to you about your detailed situation and how to make a change, because, yeah.
I'm gonna have a cochlear implant, I can't hear a word you're saying.
Okay.
But I enjoy what you're saying.
Yeah. Talk to a litigator.
She said, talk to her later.
I said talk to,
her later.
I said talk to a litigator. Where's the litigator?
Question.
Is an executor the same as a trustee?
No, that's a great question. So an executor is the person you appoint under your will, and I think of the executor as a short-term project. They're gonna submit the will to the court, get qualified to serve as executor, and then they're gonna go identify the assets, distribute the assets, file the final tax return, file the inventory, or prepare the inventory, file the affidavit in lieu of inventory with the court, and then their job is done. Once they've distributed the estate assets, the executor's job is done. It's kind of a shorter term project. Granted, that can be a 3-year process, but typically 6 months to a year is kind of the average. Then the trustee is the long-term commitment. The trustee is the person who then receives the assets and holds them for the duration of the beneficiary, their lifetime, or whatever the situation is. But the trustee is the long-term, takes care of that on behalf of the other person. So those terms are used interchangeably, but they're very distinctive.
I assume there are no time limits once you sign an official document, unless there's a change, and then it would be the most recent. Is that correct?
You are correct. I have probated wills with 1980, yeah, and there might be a need for some additional testimony that yes, this is in fact, I've talked to her about updating the will, there were no changes, this is in fact her valid will, it's not been revoked, there's not been any subsequent wills, but yeah, you're right, there's no time limit. There is a time limit on filing the will. Some folks don't realize you're supposed to file the will with the court within 4 years of the date of death for a full probate administration. If a lot of times people don't know they inherited mineral rights or that quarter interest in the ranch out in West Texas, there's these weird little kind of things you find out years later. That's okay. You just take the will to the court 15 years later and say, I didn't know I had this mineral interest, and then you can submit the will as a muniment of title. So it can quiet title on those minerals, real estate, sometimes financial assets, but the goal is to try to probate it within 4 years of the date of death.
Any more questions?
Well, my contact information, go ahead. My contact information is on the handout, so feel free to reach out with questions. Oh, it's there at the door. I'm sorry. I followed with the.
They ran out.
Oh no.
We ran out of handouts, but if you haven't signed, I have a sheet back here with your name and your apartment number, and I will get one to your mailbox.
I have a question about the compensation for an executor.
Okay.
If the executor is one of your named beneficiaries, is it okay to specify an additional amount of the estate for the executor to compensate the executor for their time?
Yes.
Okay. What are the typical
So either.
provisions for that?
So I always provide, or if in that situation, we would provide the executors entitled to compensation, and I usually use these words, commiserate with the fees charged by a corporate trustee or executor, like a bank or trust company, in the local regional area. So we're not going to go to New York where they charge outrageous fees. We're going to look at Frost Bank, Austin Trust Company, see what their fees are for estate administration, and that's what the fees are going to be based on. And the one thing that beneficiary, and I agree, like if they're doing all the work and they're sharing the estate with other people, they deserve to be compensated for their time, but it will be W-2 reportable income. So, I mean, I've had folks who are getting the entire estate, and they say, should I pay myself a fee? And no, because you're inheriting everything, and that you don't want to pay income tax on, so, yeah. But that situation is
Will the slideshow be available on the portal or?
Yes.
I can, yeah. Yes. Easy answer.
Yes, they will. Thank you very much, that's wonderful information.